Good morning. I'm Neda Sharifi, and I'm the Submissions and Symposium Editor here at Florida Coastal Law Review. On behalf of the Florida Coastal Law Review, I would like to welcome you to our 2014 Symposium, Hot Topics in Patent Law. In the expanding world of intellectual property and ever-evolving rules of patent law, we felt that it's necessary to understand the changing landscape in various aspects of patent law, ranging from procedural considerations to medical and pharmaceutical regulations. We're thrilled to have an outstanding group of speakers here for you today, some of whom I had a personal privilege of being their mentee. Our speakers have traveled from far places despite their busy work and life schedules, and we're truly honored to have them here with us today. The Law Review would like to thank the school, the administration, our faculty advisors, and our moderator for providing us with this great opportunity to learn about one of the most exciting and exponentially expanding field of law. We hope that you enjoy our program, and we welcome your participation in the Symposium Dialogue. Here to officially commence our 2014 Symposium and introduce our keynote speaker, please join me in welcoming Dean Chidi again. Thank you.
Thank you very much, and I also want to extend a warm welcome to the panelists and to the members of the community who are gathered here for this very important symposium. I would say a warm welcome, but alas, it's not quite so warm as we normally expect. But I did have a chance to look at the weather in New Hampshire, and I think this being a law school, if you grade us on a curve, I think we're doing very well. All right, so look, at its best, law school is two things simultaneously. It's a readout of intellectual inquiry. It's a place where we come to fully immerse ourselves in the law, in the life of the mind, as it were. And on the other hand, and just as important, is that we are a place where we prepare students to actually practice law. And that's something that we're very proud of. Here, I think in this symposium, the thing I like about it is that it represents the best of both traditions. It seems to be a pretty good synthesis of those two corollary goals, because on the one hand, looking through the agenda, you could see that the presentations, very intellectual, very searching, and at the other hand, I think they're really grounded in practicality of today's practice. You know, Apple versus Samsung. That's all over the news. The news these days. I was talking to the keynote presenter just before I came up, and I said, look, we were joking about patent law being esoteric, and I said, well, it's not so esoteric in a world where you can develop an app and then 3 years later sell it for $19 billion. So that's as real as it gets, right? So, so one of the things that we're doing, this is a little bit of breaking news on our part, to respond to these developments in a sign of just how important intellectual property has become in today's business world, in today's legal climate, is that we're at the beginning stages, emphasize beginning, of launching an entrepreneurial law clinic that will work with businesses and incubators downtown as part of Jacksonville's initiative to A, lure businesses into the area, and B, revitalize downtown. We anticipate that the clinic will be up and running by next January at the very latest, although we're certainly aiming for the fall. If we could do it earlier, we'd like to. And we anticipate that it will work in conjunction with the Center for Law Practice Technology to, again, immerse our students fully in the practice of law representing med tech companies, other high-tech companies, et cetera, et cetera. So this seemed to be a very timely moment to announce that for you all. And so to the extent that any of you are interested, and I hope that several of you are, please feel free to contact us afterwards, and we can give you what further details exist. So with that said, it gives me great pleasure to introduce Our keynote presenter, Professor Jeff Hawley, he is the Distinguished Fellow in Intellectual Property at the University of New Hampshire. He has had a storied career in engineering as well as patent law. He has a degree from the New York University School of Engineering, after which he began work at Eastman Kodak. For whatever crazy reason, unbeknownst to him, he then decided to study law. He went to George Washington University in DC to study law. Incidentally, my sister went to GW, so. After that, he continued to work at Kodak, where he retired in July of 2006, and then became affiliated with the law school at the University of New Hampshire in 2007. He's served in a number of leading roles in intellectual property organizations, including serving as the president of the Intellectual Property Owners Association. More about Professor Hawley. He is married with 2 sons and is a tennis player, a boater, and a photographer. And I need to talk to you offline because I still can't operate my DSLR. So.
I'll take care of that.
All right. Well, with that said, I invite Professor Hawley to the podium. Please give him a warm welcome.
Okay, how do we work this thing here? Where do I get to my slides?
I'll come to the rescue.
You'll come to the rescue? I should have done this before we started. There we go, function 5. Okay, and we advance it by that. Okay. Good morning. I don't know where to start. I've spoken with a number of people in the audience, and it seems as though we got a fair number of students, not a tremendous amount of background in patent law. So I'm going to start in I think it's 1474. But just a little more introduction. Franklin Pierce, the Franklin Pierce Law School, was founded about 25 years ago, and its claim to fame is that it was founded as an intellectual property law school. We continually rank in the top 10 in intellectual property programs. We used to be number 1 or number 2, but now a lot of schools have gotten religion and have started their own IP practices or curriculums. But it's that is our heritage. I was delighted to hear in the introduction that this school is focused on the practical aspects of actually practicing law. That has been part of our heritage since day one. We run a 2-semester course on patent practice, claim drafting, application drafting, response drafting, appeal brief drafting. That's really our flagship course. So the Franklin Pierce Center for Intellectual Property became part of the University of New Hampshire system, became affiliated a couple of years ago, and as of January 1st, we're now officially completely part of the school. So that is a little more introduction on where I come from. I'm 37 years with one company, many years in the patent department. I was the director of the patent department for a number of years, and as mentioned, traveled a little bit. So let's get started, if I can figure this out. I'm going to talk about secondary considerations. Now, I promised a gentleman over here that if there were terms, I would define them. So I'm going to do that as we go through this. But I'm going to start, as I promised, in 1474 with Venice. And I am not a historian, and fact checkers in the room can go and fact check. But the Venice was widely regarded as being one of the very first kind of formal patent systems. And the word that I want to focus on here is the word ingenious. Now, it's been long recognized that developing ingenious devices is a good thing. And in fact, I was very interested in listening to the announcement of the this establishment here in Jacksonville to try and attract business with technology and entrepreneurship, etc. That's exactly what Venice was trying to do. They would give exclusive rights to people in order to attract them to come to Venice, and so that Venice would be this center. And so this history of incentivizing ingenious developments goes back to 1474 at least. Of course, we'll skip over the statute of monopolies and jump right to our Constitution, which is the basis of our patent law. The states, in their infinite wisdom, gave up to the federal government the right to establish essentially intellectual property systems. So Article 1, Section 8 of the U.S. Constitution gives the Congress the authority to establish a patent system, and it's limited times, inventors, not just people, and we'll get into what constitutes, what's an inventor a little bit, exclusive rights. So that's some history. We're going to skip over a lot of history, and we're going to jump right to 1952. You notice I've now skipped over 500 years in, what, 2 minutes, 3 minutes? The Patent Act of 1952 is widely regarded as one of the really important changes in our patent law in our history. And it added what we lovingly call Section 103 of the patent statute. Section 103 was that section of the statute that was intended to codify exactly what the Venetians said were things that were ingenious. Over the period of our history, there had been a lot of controversy is one way to put it, but back and fill over just what constitutes an invention that has a high enough level of ingeniousness, of inventiveness, all kinds of terms thrown around for what constitutes something that's sufficiently high in originality, ingeniousness, whatever you want to call it. And it came down to 1952 when Judge Rich, or Giles Rich, who later was widely regarded as one of the basic architects of this statute, decided on this non-obviousness standard. So we'll jump forward to Section 103 so you can see where we are starting our discussion. Now, in order to get a patent in the United States, the invention has to be new, useful, and unobvious, has to be adequately disclosed. We're going to focus solely on this concept of unobviousness and how you go about establishing it in the modern day world. Now, a patent may not be obtained, etc., etc., if the difference is such that the subject matter as a whole would have been obvious at the time the invention was made to a person having ordinary skill in the art. The so-called posita, person having ordinary skill in the art. You'll see that in my slides later on. So this is the statute that establishes where most patent attorneys live. It's usually pretty easy, although there are some close cases where that you can establish that you've got something that's new. You're not going to spend the $10,000 or whatever it is to get a patent on something that's useless. And so most of the fight in the patent office on inventions and in the courts is over whether you have got an invention that has this level, that justifies the government giving you an exclusive right for a limited period. So does it meet that threshold? And that's what we're going to talk a lot about today. So now we're going to jump to 1966, a Supreme Court case, Graham versus John Deere. And the first thing they decided was, you can see that that's some 14 years after the statute was passed, the Supreme Court finally took a case up that related to it. And they concluded that the 52 Act, all the 52 Act did was it codified what we've always been saying. We're not going to say anything different. It's there are lectures on that to go on for hours and hours, and I won't get into that. they wanted to make clear that the language of Section 103 places an emphasis on the inquiry into obviousness. So, what is this general level of innovation, inventiveness, uniqueness that is necessary to sustain patentability? And they said, well, it's no different than it's always been for the last 100 years. Well, folks, it really is a little bit different. So we'll jump to the Daughters of the American Revolution. Everybody know DAR, Daughters of the American Revolution? This is one of those mnemonics that I teach that allows my students to remember what the Graham versus John Deere process is. So this is a quote. I should have put quotes on it. That under Section 103, this is what the Supreme Court says that you must do. And under the when you are evaluating a patent or evaluating an invention to see if it's patent eligible or not, the first thing you do is you look at the scope and content of the prior art. Okay, what does prior art mean? Well, that means everything that went before you. It means printed publications. It means what Carmine Gumbatz did in his garage last week. It's what existed before, and it's a term of art that we use. We call it prior art. So you determine just what is that? Just what was known before. So that's the first thing you do. The second thing you do is you determine you take your invention and you look at the prior art and you decide or try to determine what the differences are between what was known before and what you are doing. Now, the next thing you've got to do is you've got to determine the ordinary skill in the art. Are you dealing with an area of technology that only PhDs work in, so this level of skill is high? Or are you dealing with toys? Uh-oh. Do we have any toy developers in the room? Where the level is low? Just what is the level of skill in the art? Sometimes, and there are fights over this as well. Is it a group of people? Maybe it's a software developer and a hardware developer, and etc. So you determine the content of the art, you ascertain the differences, and you resolve the level of skill in the art. Daughters of the American Revolution. You'll never forget it. Okay, so determine, ascertain, resolve. And now finally we're getting to the point where my talk really begins, and that is that the Supreme Court in Graham versus John Deere said that once you're a daughter of the American Revolution and you've determined, ascertained, and resolved, then you decide whether the invention is obvious or not. And the next sentence is what we're talking about today. Such secondary considerations as the commercial success of the invention, the long-felt but unsolved needs, failure of others to solve those problems, and importantly, etc. Let's be ambiguous here, let's not be too precise. Might be utilized to give light to the circumstances surrounding the origin of the subject matter sought to be patented. An indicia of, sorry about the misspelling, of obviousness or non-obvious, these inquiries may have relevancy. Okay, so now we've got this secondary considerations. And that's what we're going to talk about today. So let's see, we're in 1966, let's jump forward to 2007 and see where things were in roughly 2007. Well, in 2007, the Court of Appeals, Judge Michel, decided a case, Pfizer versus Apotex. And the district court found that the invention in that case was not obvious. So we've got a district court determination, now appealed to the Court of Appeals for the Federal Circuit. Chief Judge Michel of the Court of Appeals is writing the decision. So the first thing that was decided here was that the evidence that the defendant had shown by clear and convincing evidence that the person skilled in the art would indeed have been motivated to combine the prior art to produce the mesylate salt of the drug. Okay, what are we dealing with here? Well, 99% of the time, you'll see some exceptions here in some of the cases I talk about, but 99% of the time, you're talking about an invention that is new. What does new mean? It means that it's not described in a single reference. Okay, and now we're trying to figure out whether the invention is obvious or not. Well, typically, what the defendant or what the examiner is going to say is, well, this reference shows most of what your invention is. This reference shows the rest. And now, oh, it would have been obvious to combine those two together. And when you do that, you get the claimed invention. So most of the time, you're combining references to get to that point. And so in this case, it was found that this mesylate salt was an obvious combination of a prior reference which showed pharmacy people, it's the amlodipine. Amlodipine? Thank you! Amlodipine. It's a heart medication, as I remember. The commercial embodiment at the time was a different salt. And it had some instability problems, and so Pfizer set off to figure out what would be a better salt for this particular active ingredient. Mesylate was an anion that was not very widely used. It was a very unusual anion to be used in. It was I think the cases say it was like 1 in 400 drugs used that as the anion, and so it was kind of unusual. But it had a combination of stability and non-stickiness. Well, do you care about non-stickiness? No, I don't care about non-stickiness, but they do. Pfizer did, because it made, if you have a sticky drug, it's like hard to make into little pills that you take. So it had this really nice combination of these two things. It was as far as effectiveness, as long as it hadn't deteriorated, it was just as good as the one that existed. So that's the invention, and they said, well, gee, nobody could have predicted this particular combination of properties. So here we get to where the courts were in roughly that time frame, which in my scheme of things is not that long ago. What Pfizer had argued was that, well, we have commercial success. We put this mesylate on the market and was very successful. It had what we believe to be unexpected properties, and therefore, even though, yeah, if you do combine these references together as one skilled in the art might do, we've got secondary considerations. We have objective indicia. We've got something that belies the fact that this might be an obvious invention. However, the court was unimpressed. And here is the language that comes out a lot in these cases, that here the record establishes such a strong case of obviousness that the unexpected superior properties don't win the day, ultimately insufficient. So you've got this whole concept in your mind that, well, you look at the obviousness first, and then you go and you look and say, well, is there anything that's going to disrupt that? Is there anything, or have you got these secondary considerations, this commercial success, and et cetera, that is going to overturn that? So that's where we are in this time frame. Okay, along comes KSR. Anybody in the room that's a practicing patent attorney knows KSR. 2007. That was the first year I started teaching after I retired, and I'm teaching. My class was about this size, about 85, and Richard Kurse was sitting right over there, and I was in the point of my lecture that we were talking about obviousness, and I was waving my arms about Venice and the statute of monopolies and all that fun stuff, and Richard raises his hand and said, Professor Hawley, he said, KSR was just decided. Oh, okay, we'll stop the lecture, and we dove into KSR. KSR is a very significant case, Supreme Court case, that deals with this issue of unobviousness. And what had come to be developed over the years in the Court of Appeals was this concept that you don't combine references together unless there is some teaching to do that, or suggestion to do that, or some motivation to do that. The so-called teaching suggestion motivation test, or TSM. And so there was a fairly simple invention, this KSR related to electronic controls for throttle pedals in automobiles. And it was a fairly simple invention as to where you connect the sensors that go into the computer system in the car that determine how much gas to give, etc. So KSR comes along. Just to back up just a second, this teaching suggestion motivation test was usually a pretty difficult test for a defendant to satisfy. If you read the references, you're not likely to find some teaching in those references to combine the two in the way that you have done it. And this reference was 1974. This one was 1985. Nobody was talking to each other. There's just it's a difficult thing usually for the defendant or the patent examiner to find. And it had become what the Supreme Court viewed as a very rigid test that was applied by the Court of Appeals for the Federal Circuit. And here is the quote that comes out of KSR that is now a very good quote for an examiner, or a very good quote for a defendant in a patent infringement suit. The combination of familiar elements according to known methods is likely to be obvious when it does no more than yield predictable results. So you no longer need this suggestion in the references to combine them. You've got this more fuzzy test that the Supreme Court announced in KSR. If all you're doing is combining familiar elements, gas pedals with sensors, and the gas pedal is doing what the gas pedal always did, and the sensor is doing what the sensor always did, that's likely to be obvious. So the Supreme Court threw out the TSM test and said no more rigid rules. And here's the other one. Here's the other quote from KSR that's often used by defendants or examiners. If you've got a finite number, a predictable solution, known options, you anticipate success, it's likely to be a product not of innovation. So here we've got this concept of innovation rather than obviousness. The Supreme Court is frequently loose with their language, but of ordinary skill, and another bugaboo phrase, common sense. So now the examiner says, well, you take this reference and you take that reference, it's only common sense to combine them. So you don't need a teaching suggestion motivation anymore. So there we are, KSR. Fortunately, in my view, the Supreme Court did mention this concept of secondary considerations. Graham set forward a broad inquiry. Remember, daughters of the American, determine, ascertain, resolve. You'll never forget that. Although my students, about half of them do. Set forth a broad inquiry, and where appropriate, to look at any secondary considerations that would prove instructive. Okay, so like the district court, finally we conclude that Teleflex has shown no secondary factors to dislodge the determination that it's obvious. So apparently this KSR case says, well, you determine that it's obvious, and then if you've got something that dislodges that, well, that's a concept you'll see is beginning to be eroded. Interestingly, there was no discussion by the Supreme Court of the secondary considerations of what their strength was, weaknesses, whatever. They just said, well, we've decided it's obvious. Essentially, we don't have to go on to the next step because it's so obvious. It's the feeling that you get. It's not precisely what they said, but certainly the feeling that you get. Okay, Now you go to Boston Scientific versus Cordis, 2009 case, after KSR. And what I'm going to be suggesting here is that with this broader expansive concept of what is obvious, patentees, patent applicants have been forced or have grasped what they can, and what they can grasp is this concept of secondary consideration. So it used to be prior to KSR, in my view, that you didn't have to spend too much time on secondary considerations because the court was going to dismiss them anyway. You had a powerful TSM test, teaching suggestion motivation test, that you could use. So you didn't need to dwell too much on these secondary considerations. Well, after KSR, that's one of the few arrows you've got left in your quiver as a patentee. So my view is that more and more people have put more and more effort into arguing that they've got these objective indicia, they've got secondary considerations that even though this invention looks like it might be obvious, it really, really wasn't, folks, and I should get my patent. We've got a bad guy infringer here, I should get money. So, okay. This case, Boston Scientific versus Cordis, is one of the many, many cases in what I call the stent wars. It was alluded to earlier, Apple versus Samsung are the smartphone wars. They're the modern wars. The stent wars were also very famous. So you've got a person with a blockage in an artery. I'm getting to the part of my life where I'm concerned about stuff like that. They put in a piece of metal, they expand it, so now you don't have as much of a blockage anymore. Well, that sort of works, although there's controversy around that. And so what had been developed over the years is a stent, that thing that expands your artery and opens it up so that you can play tennis. And they would put some coatings on it with some pharmaceutical composition. Drugs is a bad word. Pharmaceutical composition that allows the stent to live longer in your heart, so you can play tennis for another couple of years. So a lot of inventions, tremendous number of inventions. There are inventions on the configuration of the openings in the mesh that opens up. There are all kinds of inventions. This one had to do with a coating, and it was actually two coatings, a drug coating and then an overcoat. So it was a two coating. That's where we were in this time frame. The jury found that it was not obvious and that it was infringed. The district court noted some of these secondary considerations. The two references that had to be combined together, people had failed for a very long time to make that combination. Those references were lying out there and nobody did it. Well, isn't that a pretty strong indication that it's not obvious to do if nobody did it? There was praise for the commercial embodiment. That's one of the, remember in Graham versus John Deere, commercial success, long felt need, etc.? Well, here's an etc. Praise for the invention. Good secondary consideration. We're going to. I should not say secondary consideration anymore. We're going to get away from that in a little while. And commercial success. CAFC was not convinced. They reversed. This was an unusual case because it wasn't really the combination of two different references. It was the combination of disclosure in two parts of the same reference. Actually, it was two figures in the references that were side by side. So neither one of the figures had all of the limitations of the claim, but when you took features of one figure and features of the other figure and you put it together, now you got the claimed invention. So it's a little different than most. Who was our Judge Lurie? I knew it. Judge Lurie. Oh, Judge, you should not have said this. Please. It does not require a leap of inventiveness. Well, what happened to Section 103? It's not whether it's inventive or not, it's whether it's obvious or not. Please don't muddy the water. Well, fortunately, this leap of inventiveness hasn't gotten a lot of traction because if it did, it just takes us back to the pre-1952 Act days. So please don't say that, Judge Work. So, we've still got this concept in Boston Scientific, the weak secondary considerations. Well, in whose opinion is it weak? It wasn't weak in the opinion of the jury. It wasn't weak in the opinion of the district court. It was weak in the opinion of the Court of Appeals. So we've got weak secondary consideration of unobvious do not overcome the strong prima facie showing. In the interest of time, I got 15 minutes left, so in the interest of time, I'll move on. Another quote that gives you the same kind of feeling. We've got the strength of the prima facie showing inadequate to overcome a final conclusion. So we've made a final conclusion. Final conclusion? Why even? And now these secondary considerations don't overcome a final conclusion. Think about that as we go through some of the other cases. One of the things that's disturbing about the Boston Scientific case is they did discuss some of the secondary considerations, but there are others they didn't even mention. For example, they didn't mention the fact that this invention had been praised by peers and that there was commercial success. So, anyway. Okay, now we're getting some better cases. Perhaps you can tell, I'm opinionated, remember? I'm opinionated. I am a patentee's patent attorney. I believe in the patent system. I believe that in strong patents that protect lots of investment. Maybe we'll get into some of that this afternoon. While I've often been a defendant also, my bias is towards the patentee. So we've got Rolls-Royce versus United Technologies. Has anybody been on an airplane? Next time you go to the airport and you're waiting in the lounge and there's this big plane sitting there at the deck, look at the engine on the plane and you will see that it's got blades in it. And if it's a modern engine, those blades look really funny. They've got weird shapes. Well, Rolls-Royce invented that shape. And what Judge Rader did in 2010, Court of Appeals of the Federal Circuit, is he affirmed the non-obvious finding. The district court had found that if it was non-obvious, he affirmed that. Swept fan blades. You see the tip of those blades are angled in a particular way. What that apparently does is these blades generate these shock waves, and the way you configure the blades, they cancel each other out and blah, 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 blah. And if there's a physicist in the room, they can explain it to you. So there was an interference between Rolls-Royce and United Technologies. Interference. What's an interference? Well, an interference happens when two people claim the same invention at the same time in the patent office, and the patent office at that point in time, we're different now after the American Invents Act, has to determine who was first. That was our law back in those days. So there was an interference, and these two companies are arguing over who should get the rights. Rolls-Royce lost in the patent office in the interference. They appealed to the district court. They won in the district court. And we won't get into this. This is the combination. The combination part. And essentially what the panel in the Court of Appeals found was this is an unobvious invention. And they went through an extensive analysis of there was no real way to predict what angling the blade at the tip would do, and there were no standard tests to determine this that had to be developed, and so there was no predictability of success. All that stuff that relates to whether the invention was obvious at the outset was all about. And then sort of gratuitously, quite frankly, they went on to look at the secondary considerations. Now, why Judge Rader did that, I don't know. He'd already decided that it's unobvious. You don't need secondary considerations. You're done. But he went on anyway, which to me suggests that these secondary considerations are important. Maybe he didn't need to decide the case, but back in 2007, 2008, he would have found it unobvious and not even talked about the secondary consideration. This suggests to me the resurgence of secondary considerations. Okay, so we've got the beginning of these of a line of cases which begin to suggest that, well, maybe these secondary considerations, these objective indicia, are the best independent evidence of non-obvious. In this case, it reinforced and substantiated and cemented the unobviousness of the invention. Long felt but unresolved need, achieved commercial success, received industry acclaim, all of the wonderful kinds of things that you can argue in litigation. What was the improvement? 1.8%. 1.8% in efficiency. Folks, when you're burning thousands of gallons of jet fuel, 1.8% is a pretty big deal. And that's what they found here. But remember that 1.8%, because we'll get to another case later on. Awards, etc. Okay, so that's the Rolls-Royce case. We move on in 2010, and Judge Moore, Court of Appeal for the Federal Circuit, Transocean versus Maersk. You see that all over the place, on containers and everything else. This was an invention that related to oil drilling rigs. Improved apparatus for conducting offshore drilling. And used to be, before this invention, you would put a pipe in and you would drill down and you'd get to the end of the pipe and you'd have to pull it up and you put another pipe in, drill down, put it. Well, this had an auxiliary advancing station, and how it works is all in the case, and you can read and understand it. But it was this two-station thing instead of a one-station thing, improved the efficiency greatly. Long felt need, commercial success, and here we've got another etc. from Graham versus John Deere. Copying. You come out with an invention and all your competitors copy it. Well, why didn't they do it before? If it was so, I almost said some bad word. If it was so obvious, why didn't they do it before? Well, now they copied it. Okay. First of all, they agreed that the references establish a prima facie case. Apologize for the PowerPoint here. I was doing these on different versions. And formatting goes crazy. It is not simply enough to show that the references disclose the claim limitations. It can be important to identify a reason that would have prompted a person of ordinary skill in the art, and they nevertheless found it prima facie obvious. But now we go to the secondary considerations. Okay, it's prima facie. It means we've established enough of a case so that the patentee is well advised to say something more. Otherwise, we might find against it. That's kind of prima facie. There's enough there to I won't say shift the burden, because that's another controversy. The burden is always on the challenger, but the cases suggest that the patentee is well advised when this has been established to come up with something else. So we've got industry skepticism, another etc. We've got industry praise. It was one of the top 50 innovations in Drilling Monthly or whatever the magazine, I don't remember the name of it. Commercial success. This dual station drilling rig commanded a licensing premium. There was copying by others. Now here's where we are in 2010. The district court, now we're in the district court arena, erred by failing to consider secondary considerations. Our case law is clear. Well, it wasn't clear, but now it is. that it must be considered. You can't just say, well, it's so obvious that we're not going to bother spending another $1 million on this secondary considerations issue. You must consider it. And, well, it's true, we've held in individual cases that if you've got a really strong obviousness case, these secondary considerations aren't going to be very important. They're not going to overcome that. But it's a case-by-case determination. Lawyers love case-by-case determinations because they can bill hours on that. Okay? It's clear that the district court must always consider. Now, is that a different feeling to you than what we had in 2007 and 2008? I think so. I think this is another case that represents a resurgence. But this case will tell you that, yeah, there's been a resurgence, but it's not a magic bullet. It's not always going to work. You still must consider it, but you're not, just because you think you've got secondary considerations doesn't mean that you're always going to win. High-tech stuff, chewing gum. Anybody chew gum? Nice fresh feeling? Ba-da-ba-dum. Cooling sensation when chewed? Wrigley's? Cooling sense, really important invention in the scheme of world history. But anyway, we've got Cadbury used menthol. We all know that menthol has a cooling sensation, and a compound called WS3. Wrigley had a patent that used menthol plus WS23. Well, these were compounds in the same class. And we've got this unexpected result. We've got unexpected heightened cooling sensations. We won't go further into some of these. But it'll give you an idea of what you need to show if you want to show unexpected results. Wrigley needed to demonstrate that the results were unexpected to a significant degree. Oh, the litigators love that one. To a significant degree. Well, what's significant? 4? 1.8%? Than what was already known. Argued commercial success. Problem the court found with that is that there were a lot of differences. Wrigley versus Cadbury, one of them had great commercial success with their gum compared to the other, but there were more than just the differences between this WS3 and WS23. There was more than that. There was different sweeteners, there was different levels of sweeteners, there was whatever. And so they said, well, we can't determine that the commercial success was due to the invention. This gets us to a very important point that is now becoming a real chain of law. There must be what is called a nexus. There must be some relationship between in this case, unexpected result, or commercial success and the claimed invention. One of the more interesting cases is in the smartphone wars, Apple versus Samsung. Apple tried to shut down one of Samsung's smartphones and wanted a preliminary injunction, and it went to the Court of Appeals, and the Court of Appeals said there must be a nexus between the claimed invention and the consumer demand, which is part of the inquiry. Well, ironically, the phone that was at issue was the nexus. So we got the nexus with the nexus, which is kind of fun to lecture about. There are too many differences, cannot tell the results at the proper nexus to the claimed invention. Okay. Let's go on to, we're running out of time here. Wrigley versus Cadbury. I have provided in the materials copies of these cases that I've highlighted, so If you're lazy like me, you don't have to read the whole thing. You just have to read what I've highlighted, and you get most of what you need, and then you get to the parts that you might be interested in a little quicker. The dissent. Judge Newman. Judge Newman is well known for her dissents in the Court of Appeals. I saw a chart at a conference in Naples recently where a law professor had spent a great deal of time mapping out all the dissents in the court. And, well, it was sort of interesting. Nothing I could do anything about, so. The dissent. Judge Newman is really complained about a couple of things. One is that the way that the court in Wrigley versus Cadbury approached it was really, in her view, was shifting the burden from once you've got a prima facie case, then the burden shifts to the patentee. Well, her view was that the burden is always on the challenger. And she goes into an extensive rebuttal of the majority's analysis of the secondary considerations that you'll see another judge in a minute who has done a similar kind of thing. I'm running out of time. Darn it. This gets to the point I made earlier, that we've got this situation where it looks like the court made this final determination of unobviousness, and then sort of considered that's not what you're supposed to do. The secondary considerations, the objective indicia, are all things that you need to consider together with whether to combine the references, etc. And then you make the obviousness determination. It isn't first and then second. This again to me is a little bit of a shift in the feeling of the cases from before. Okay, I want to get to this case just since I'm out of time, and there are a few things I want to say at the end. Apple versus ITC. Well, we've seen a case now where the Court of Appeals has admonished a district court. You failed to consider secondary consideration, objective indicia. That's wrong. You must consider these objective indicia. Here in Apple versus ITC, different forum. The ITC is a place where you go to try and get goods excluded at the border. Different judges, different procedures, different remedies, different. Here the ITC failed to consider the objective indicia. And anybody have an iPhone? Anybody not have an iPhone? 2 touches. You touch the screen with 2 fingers and you go like this and it gets bigger or little. 2 touch. That's the patent. 2 touch makes it bigger or smaller. It turns out to be a fairly interesting technical challenge for a screen to sense 2 different spots at the same time and do stuff. So anyway, that's a very important Apple patent. Anyway, prior to even mentioning the secondary considerations, the administrative law concluded that the evidence clearly and convincingly shows it's unobvious. Error. Can't do that. Okay. Leo Pharm versus Ray. Teresa Ray. Unfortunately, she's left the patent office. She was a great commissioner, or acting commissioner. In any event, here we've got a situation where the patent office has rejected a claim, and the applicant has appealed. Court of Appeals says, you didn't consider secondary considerations. That's wrong. So now we've got a district court that must do it. We've got the ITC that must do it. We've got the patent office. They're sending a signal, folks, that this is an important inquiry that you've got to do. The reason I like this case, this is from last summer. It's a Judge Rader case. It's almost a tutorial on how you argue various of these objective indicia. He goes through them all. He's got motivation to try. He's got solutions not predictable. He's got unexpected properties. He's got commercial success. He's got unknown problem. He's got a long-felt need. This case is chock full of good analysis of these secondary considerations, and I recommend it to you. We're gonna not do the last case, although it's a fun case. So now, so what? So what? Now it is crystal clear in your mind exactly what we're talking about here. We're talking about objective indicia. We're talking about secondary considerations. As a practitioner, what does that mean to you? What do you do differently today than you might not have done before? This gets to the practical bent of our school and your school. Oh, and I always like to, when I discuss a case, I always like to end. So, okay, you were the losing party. What would you have done differently so that you didn't lose? And we have a nice discussion about that, rather than just say, okay, this is the case, and see, those jet blades were really fun to talk about. Okay, now what do you do differently? What would you have done as a loser differently? Well, what do you do now that you know about the importance of these secondary considerations? Well, a couple of things that you do. When you are sitting down with your inventor for the first time, ask about him. Has anybody praised this invention? I didn't used to ask that question. I mean, you learn the invention, you're focused on this prior art, you're focused on, well, does this fit with that? Is there some teaching suggestion, motivation? Ask about all these secondary considerations. One of the things that comes up in this case I didn't have, one of these cases I didn't have a lot of chance to talk about, is one of the last cases, is that the two references that were combined together, they had been around for a very long time. So why didn't people, for all this long time, if this is such an obvious invention, why didn't people make it? Look at the references, look at the dates. This is one of the things I used to do is, well, Mr. Examiner, you've cited two references that are 25 years old, and nobody combined them before. Doesn't that tell you something? So ask about it. Also, from the other side, look at the record. With all due apologies, inventors are notorious for saying really bad things in the record. Say, well, gee, I expected this to work. Oh no, we've got to deal with that problem and deal with it. So what do you do differently? You ask about these things when you sit down to write your patent application. Unfortunately, a lot of these things don't occur until after the invention has been commercialized and it's out in the world and it has commercial success and people see it and they praise it and all that stuff. So that's tough. You may have to sort of ad hoc make these arguments. But when you're talking to your inventors and you're interviewing them, see if you can get into your notes some of these things, because they may turn out to be important. As a defendant, you look for the other stuff. You submit interrogatories. Did you ever say that this invention was obvious? Did you ever say it could have been easily made? So look for some of these things that might help you as a defendant. I run over my time, but can I answer a question if there is one? Yes, sir.
I'm an inventor.
Good for you.
Thank you. And
we need you guys.
That's part of the reason why you guys are here.
That's right.
What do I need to do to make sure that my patent attorney covers these secondary considerations? Because I want the broadest protection possible.
The lecture really isn't about broad protection. That's 6 or 7 other lectures. What this is about is validity. Do you have an invention that meets the new, useful, and obvious criteria? And then we'll talk about the whole area of how you claim it and whether you get, how you interpret claims. And there's a case that's being argued this week or next week on exactly that issue, on scope. But just to get back to your question, how do you make sure you're a patent attorney? Well, since you are an enlightened inventor and have come to this symposium, you can say, well, why aren't you asking me about whether this had some commercial success because I got it. Oftentimes you won't have it because it's too early. But one of the things that used to bother me about the examination process was that the examiners, the only thing they ever see is success. They never see the 10 failures. So if you've got a situation where you've made this invention, you've discovered something after testing 8 or 10 other things, make sure your patent attorney understands the pain that you went through in order to get there. Because that's again kind of an indicia of a long-felt need, failure of others, failure of yourself to make the invention. So make that apparent to your patent attorney that you tried a lot of things and this is the only one that worked. And yeah, you go back to these references that are 20 years old and you can piece them together and poke and prod and make them fit. But it wasn't obvious to me. So that's what I would tell you to tell your patent attorney. Any other questions? Nobody's asleep. I've accomplished my goal. Yes, sir.
With this resurgence of secondary considerations, has the court determined how much weight? Because it seems like more and more weight is going to be.
No, it's yeah, and there's a lot of churn going on in a couple of cases on how much deference to give to the district court and their determinations of things. But how you weigh it? You have a technical background? Yeah, you're looking for the third decimal place answer. This is law, folks. It's what is a reasonable man? What is a person having ordinary skill? These are all not things that you can measure. So weighing them and say, well, that one weighs 4, this one weighs 2.5, therefore 4 wins. It doesn't work that way. It's how your attorney can convince. Yes, sir.
Yeah, I'd like to thank the school for inviting the North Florida Inventors and Innovators Group to the seminar. I'm a member. I think I've seen you there before. And there's no... we're a group of guys and girls, ladies, that get together once a month to discuss problems that come up with applying for a patent.
Mm-hmm.
And I am not aware that the students might not know that this group even exists. And it might be good for someone from the school to attend one of our meetings and be represented. And
fine with me.
I've learned a lot today.
Already?
Yes. I have an idea where two existing patents would come together, and I am in a quandary of who to go see to make sure that the idea is legitimate and is patentable.
That's why we need patent attorneys. Okay, anything else? I'm way over my time. Thank you very much. Appreciate your time.